This is Judge Jones. The time is 1 o'clock Central. Today is June the 6th, 2023. This is the docket for Houston, Texas. On the 1 o'clock docket, we have the jointly administered cases under case number 23-50038, Lifesize, Inc. Folks, please don't forget to record your electronic appearance. I think I got the link up. First time that you speak, if you would, please state your name and who you represent. That really does help the court reporter in the event that a transcript request is made. We are recording this afternoon using CourtSpeak. We'll have the audio up on the docket shortly after the conclusion of this afternoon's hearing. And with that, again, I'll say it once more since we've got a couple of stragglers. The hand-raising feature is activated. If at any time you wish to speak and haven't already done so, you only have to do it once. 5-star on your telephone. And with that, who is starting us off this afternoon? Mr. Pomerantz, is that you?
Good afternoon.
Yes, sir.
Yes, I will start us off, but then hand it off to my able colleague. Good afternoon, Your Honor. Jeff Pomerantz from Pachilski, Stang, Deal, and Jones, proposed counsel for the debtors in possession, along with my colleagues, including Ben Wallen and Chiamacco, who will handle many of the proceedings before Your Honor today. I did want to point out, Your Honor, that yesterday the Office of the United States Trustee has appointed as creditors committee. We do not know if they have yet retained counsel. They have not reached out to us yet, but having represented creditors committees in a number of cases, as Your Honor knows, and knowing how Your Honor would like the creditors committee's input into the debtor in possession financing, we have voluntarily agreed to continue the hearing on debtor possession financing. We don't need any more draws on the interim, and we have sufficient time within the milestones in order to get a final DIP order hearing. And we've been asking for something, to Your Honor, perhaps late next week, either the, I guess will be the 15th or the 16th, which hopefully would give the committee sufficient time to get counsel and to engage with us in any discussions that may have.
Certainly. Thank you. Ms. Thomas, do you know if the organizational meeting has happened yet?
Yes, I believe that Mr. Jimenez with my office conducted that yesterday afternoon.
Good. All right. Just so I don't forget, Mr. Pomerantz, and I very much appreciate your willingness to extend the hearing. Do you have a preference of Thursday versus Friday, just with your team's calendar?
Yeah, I don't know if we have a preference for either, but again, committee counsel presumably hasn't yet been engaged. Probably to give them more time, we would take Friday. But if Your Honor had Thursday, then Thursday would be fine too. But so we could do either day. Let's
do this. I've just got a better block of time for Thursday, so let me set you for 10 o'clock Central on Thursday, and if you get committee counsel and they want to move to Friday just because they need that extra day, I will figure out a way to make it work. But right now, Thursday's easier. All right?
Thank you very much, Your Honor.
Okay. Thank you.
We do, however, want to proceed with the bid procedures hearing. I think our view, and I think you share the view, that bid procedures are generally procedural in nature. Mr. Wallen will handle the bid procedures hearing. I think there may be one outstanding issue to resolve with one party who requested some language changes. And then after, he would turn over to Ms. Mackel to deal with the final hearing on the cash management motion.
All right. Thank you. Let me ask, anyone else wish to make what I'll just take as general opening comments? All right. Mr. Wallen?
Good afternoon, Judge Jones, Ben Wallen, Pachilski, Stang, Deal, and Jones, proposed counsel to the debtors. Judges, you are aware the debtors are here on their bid procedures motion filed at docket number 48 on May 19th, 2023. As you've seen, we do have a few objections, as Mr. Pomerantz noted. I believe there are outstanding objections or issues on each of them. And just so you're aware, there's an objection by Cigna at docket number 78, Life Insurance Company of North America at docket 79. As well as an objection from the Office of the United States Trustee there at docket number 81. We did file an amended proposed order before the hearing. I know we got a couple of them on file. The right one, Judge, to look at is the one at docket number 95. We did try and include some language that was proposed by what I'll refer to as the insurer parties. I think that gets us some of the way there, but I don't think it fully resolves. But I'll let Mr. Weisler, I hope I'm saying that correctly, address that with you at the appropriate time. We also did file a witness and exhibit list at docket number 84. So, Judge, at this time, the debtors would move into evidence. Exhibit 1 to that witness and exhibit list, the declaration of the debtor's co chief restructuring officer, Mr. Mark Bilbao, which is attached as Exhibit 1 and appears in the docket at docket number 84-1.
Great. Thank you. Any objections? Right. Then the declaration is admitted. Anyone wish to cross-examine? All right. Thank you. Mr. Bilbao, you get off easy today. I'll keep working on that to try and make it more difficult for you. Mr. Wallen?
Well, Judge, not so fast. We do have a proffer for Mr. Bilbao as well, if that's acceptable to you, Judge.
Okay. Certainly.
So, Judge, if called to testify, Mr. Bilbao would testify that he understands that debtors' bidding procedures are a continuation of the strategic process. The debtors began with the proposed investment banker, Piper Sandler, in October of 2021, as discussed in his first day declaration. He would testify that he believes the debtor's ongoing sale and marketing process, as well as the bidding procedures, will maximize the value of the debtor's assets through a going concern sale to the benefit of all parties and interests and the debtor's estates. Mr. Bilbao would further testify that based on his experience, he believes that the bid procedures are customary and reasonable under the circumstances. He believes that the bid procedures strike the right balance between providing adequate notice, implementing a transparent and competitive process, and promoting participation of other potential purchasers and other parties in interest, while maintaining an appropriate pace for the debtor's Chapter 11 cases and maximizing the value of the debtor's estates. In that regard, the timing and deadlines in the bid procedures order are crucial to maintaining the expectations of interested parties, as well as to close a strategic transaction within the time negotiated with the debtor's DIP lender in order to preserve the going concern value of the debtor's estates. Additionally, Judge, Mr. Bilbao would testify that the debtors are seeking in the bid procedures motion court approval of their designation of In-House Interactive Inc. as their stalking horse bidder in accordance with the asset purchase agreement dated May 16, 2023. Mr. Bilbao would further testify that he believes the consideration and assets included with the stalking horse agreement, as well as the breakup fee and expense reimbursement requested in the motion, were negotiated at arm's length and in good faith. In that regard, the timing and terms of the stalking horse agreement were heavily negotiated between the debtors and crucial to entering into an agreement with the proposed stalking horse bidder. Moreover, Judge, Mr. Bilbao would testify that the breakup fee and expense reimbursement were necessary to induce the stalking horse bidder to act as such. Based on Mr. Bilbao's experience, he would testify that he believes the presence of the stalking horse bidder will establish a reasonable floor against which other third parties may bid against, while ensuring that the debtors have a reasonable bid for substantially all of their assets in hand while they continue to market their assets for the highest and otherwise best offers available. As a result, Mr. Bilbao concluded his testimony by stating that he believes that the relief requested in the bid procedures motion is appropriate, reasonable, and in the best interest of the debtors, their estates, and all of their stakeholders, and should be approved by the court. That would conclude Mr. Bilbao's proffered testimony, Judge.
All right. Excuse me, Mr. Bilbao, if you would please raise your right hand. Do you swear from the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Did you listen carefully to Mr. Wallen's proffer of your testimony?
Yes, Your Honor.
Did you understand it all?
I did.
Everything he told me true and accurate to the best of your knowledge?
It is.
And do you adopt his statements as your sworn testimony this afternoon?
I do.
Thank you. I'll accept the proffer. Does anyone wish to cross-examine Mr. Bilbao? All right. Didn't get much to offer. Mr. Bilbao, thank you, sir. All right. Mr. Wallen, you want to walk me through the status of the current objections?
Yes, of course, Judge. I'm also happy to run through the motion, but I can hop over that and go directly to the objections if you prefer.
I've had time I have not looked at the red line at 95, and I want to do that, but I had looked at the procedures as well as the proposed order that was originally attached. I've read the objections. I just want to understand your view of where we currently stand.
Of course, Judge. So we did include some additional proposed language in paragraph 16 and 17 of the amended proposed order at docket number 95. It's a little ways down there. That provides advance notice of the debtor's decision about whether or not to assume and assign the executory contracts at issue in those objections. The open issue remaining there, as I understand it, is whether or not that advance notice will be definite, whether or not the debtors will have an out to continue prior to the closing of the sale to continue to adjust whether or not that those will be assumed contracts underneath the bidding procedures. The debtors included that proposed language for additional notice at the request of those insurer parties. But the issue again is whether or not that's irrevocable. The debtors are happy to provide that further notice included within those paragraphs to the insurer parties to help resolve their concerns, but do not believe that they should eliminate the optionality with an advance decision in the event that circumstances change right there before the closing. We certainly intend to provide them as accurate as advance notice as possible, but there's nothing that stands out in these contracts as far as we're aware, but they should have an ability to disrupt the debtor's sale process with advance binding notice, unlike other executory contract counterparties.
All right.
I'm happy to turn now to the trustee's objection.
Before you move on, so excuse me again, my apologies. I want to make sure I understand what you're proposing. You're saying that where you all have not agreed is if you send notice that you intend to assume, there's an issue about whether or not you can change your mind after you send that notice, correct?
Correct, just the advance notice, Judge. So they would still be subject to the hard deadline at the end of the day with all the other executory contract counterparties. It's whether or not that advance notice.
And if you send an advance notice rejecting, do you still want the ability to change your mind?
Judge, we're only considering providing advance notice, I believe, with respect to the assumption of assignment, or we would deal with rejection down the line.
So rejection would just take place when you get to the deadline by operation of the process, right?
Exactly, Judge. And we would file a further motion, or it could be potentially underneath the plan as well.
All right. Who do we have representing? I'm just going to call it the insurance entities today.
Good afternoon, Your Honor. Jeffrey Whistler on behalf of Cigna Health and Life Insurance Company and Life Insurance Company of North America.
Thank you, Mr. Whistler. Help me understand what your concern is, if you would, please.
Sure. Your Honor, there is a pro-hoc motion for my admission filed by Hunt Andrews, my co-counsel.
I very much appreciate your telling me and consider it done.
Thank you, Your Honor. Cigna provides medical and dental and vision coverage for the debtor's employees. Line provides life, disability, and accident insurance for the debtor's employees under their employee benefits plan.
Right.
Your Honor, what we're at bottom, and I do kind of want to go through this so Your Honor understands the details of what I'm going to say, but in general, the process that the debtors have asked you to approve really provides no meaningful notice to contract counterparties as to what's going to happen to their contracts in the context of this sale. So they propose to file and serve a cure notice, but the notice itself, the bid procedures, and the order they're asking Your Honor to sign says that notice doesn't really mean anything because they can add or remove contracts from that list at any time. What it also provides for a supplemental cure notice. But again, the supplemental cure notice, the order they're asking Your Honor to sign, and the bid procedures themselves say they can add or remove contracts from the supplemental notice list at any time prior to closing.
Right.
And in fact, the debtors go on to say that none of those notices mean anything because only the contracts that are on the final list or schedule attached to the final APA are the contracts to be assumed and assigned as part of the sale. And there's no provision to serve that or file it or anything else. So the final list of the contracts to be assumed and assigned will be a complete unknown to contract counterparties. Contrast that with a couple of things, Your Honor. One is that the order the debtors are asking Your Honor to sign today says that these procedures are reasonably designed to let contract counterparties know what's going to happen to their contracts, and it's not. The other thing they're going to do at the sale hearing, Your Honor, is they're going to ask you to sign an order that says the debtors can assume and assign the capital A, capital C assigned contracts or some other similar term, but neither the court nor any counterparty at that hearing will know what you're approving. They're asking Your Honor to sign a blank check. They're asking Your Honor to say, well, approve the assumption and assignment of this undefined list of contracts, and we'll decide later, all the way up until closing, what those contracts will be. And there's no provision of the bankruptcy code that allows that sort of flexibility. In fact, to the contrary, Rule 6006F2 says if a debtor files an omnibus motion to assume and assign contracts, it needs to list the contracts that it's going to assume and assign, or just assume. And the purpose of that rule is obvious. Number one, if the debtors are going to ask Your Honor to assume, for permission to assume contracts or assume and assign them, the court and the parties need to know what those contracts are. Otherwise, on the first day, the debtors could file an omnibus motion to assume contracts or assume and assign contracts and say, hey, Judge, go ahead and sign this order. We'll send out some notices that we can change later at any time during the case when we decide to do that, whenever we decide to make it final. We won't really let anybody know what those are because they're going to be attached to an APA that nobody will ever really see. So, and I know that's a little extreme, but it sort of demonstrates why that rule is there. So what we ask the debtors to do is put language in the order that says, look, prior to the sale hearing, X number of days prior to the sale hearing, just tell us, are you trying to assume and assign these contracts, or aren't you trying to assume and assign these contracts as part of this sale? It doesn't affect what they can do later after the sale hearing through another motion. It just says, under this motion, please tell us, are you trying to assume and assign them or not? Because then we go into the sale hearing and we understand what they're trying to do. And this is a real world problem for the insurance companies because the employees know the companies are for sale. So they call the insurance companies, and this obviously isn't the first one I've been involved in. Your Honor's seen our objections before. They get calls and the employees say, what's going to happen to our coverage? Are we going to stay with Cigna because I have these Cigna-approved providers? Are we going to stay with Lina because we have this accident coverage and we want to know whether it's going to continue? And my clients can't answer that question, and they won't be able to answer it before the sale hearing, after the sale hearing, before the closing, or even after the closing, under the procedures that the debtors are proposing. So let's look at the language that the debtors put in 95-1, which is partially what I proposed.
Can you just tell me which paragraph you're at so I can follow along?
Sure. Let's look at paragraph 16 of 95-1.
Okay.
Now, for the most part, Your Honor, this language is identical to the language that is in the Pipeline Health Sale Procedures Order that Your Honor signed and the IAH Auto procedures that I know was in your district. I don't remember whether it was Your Honor, and I apologize. But in any event, on page 12, about 6-7 lines down, you'll see a line that starts with 3 business days prior to the hearing.
See it?
So 3 business days prior to the hearing, written notice of the debtor's decision. Now, what the debtors did there is they removed the word irrevocable. So what all the prior language said was the 3 business days prior to the sale hearing, they have to make an irrevocable decision whether under this sale and this motion they're going to propose to assume and assign or not. The debtors removed the word irrevocable because they want to change their mind. They want to be able to change their mind. And I understand that. That's what they asked for in their sale procedures motion. So when you take out the word irrevocable, this paragraph does nothing. It doesn't really add anything. It's exactly like what they're proposing in the first place, which is they're going to send out some cure notices that may or may not tell us what's going to happen to our contracts. The other thing the debtors did was they added the suffix, probably fourth from the bottom, as part of the proposed sale, and then there should be a semicolon, and it says, provided that to the extent that the stalking horse bidder is the successful bidder, with the express written consent of the stalking, well, I'm not sure I'm reading that right, but in any event, the effect of that clause is, whatever the debtor's decision, whether irrevocable or not, it's meaningless unless the stalking horse purchaser gives its written consent.
Sure.
Well, I don't know if they've given written consent. And what I proposed was, okay, well, the stalking horse bidder can give written consent prior to the debtor sending a written notice prior to the sale hearing. But if you just leave it as is, which means the debtors can send signa and line in irrevocable notice, but it doesn't mean anything unless the stalking horse purchaser gave written consent, and I'm not going to know whether or when they gave that. So at bottom, Your Honor, my clients just want to know, prior to the sale hearing, is this motion proposing to assume and sign their contracts or not? It's that simple. We're not trying to compel assumption and assignment. We're not trying to compel otherwise. We just want to know, before we get before Your Honor at the sale hearing, what are they doing? What do they want to do? So we know how to approach the sale hearing, and so my clients can answer the calls that they're getting from employees.
Got it. So, Mr. Whistler, help me understand. Let's assume that 3 days prior to the hearing, you get the notice that says, we're going to assume. And let's assume for whatever reason, because, I mean, this isn't going to be driven by the debtor, it's going to be driven by the purchaser, right? So let's assume they get to the closing table and something changes and they now want to reject the agreement. How does that affect your position at the sale hearing versus just having notice of what's going on? Because the latter part I can fix.
I'm not sure I understand Your Honor's question. Let me try to answer it, though. What Mr. Wallen said earlier is right. This motion does not propose rejection, and we're not.
No, but so
neither the motion nor the.
So if I could just ask you, just for right now, forget what Mr. Wallen said.
Okay.
So 3 days beforehand, you get a notice that says we're going to assume. That will dictate what you do or not do at the sale hearing, and I'm assuming it's primarily you want to do an analysis of who the owner is going to be. Am I too far off?
I understand where Your Honor's coming from, but the real focus here isn't.
No, I'll get to your real focus. Just bear with me.
Okay.
And just go.
No, Your Honor, that's
okay.
not it. Because
so you don't care. All right. So 3 days before. No, please, Mr. Whistler, I've listened to you. I did not interrupt you not one time. And you've done it to me 6 times already. So please just indulge me. I'm genuinely trying to understand. Is that asking too much?
No, Your Honor.
Thank you. 3 days beforehand, you get a notice that says we're going to assume. You go to the sale hearing, sale order gets entered. At closing, for whatever reason, there's then the decision that the contract's not going to be assumed. So I'll leave the word rejection out of it. How does that change your view of the sale versus just being advised of what's going to happen?
The sale now transfers the operation of the debtors to a third party,
right,
including for all the employees, that between the time I received notice, my clients received notice in the closing, my clients had told employees who called that the benefits would be going with the sale and would continue if the employees went to the new employer.
Okay.
And now that those benefits will be disrupted because under Your Honor's scenario, they will decide not to have those contracts assigned to the buyer.
Right. How does that affect your client?
It affects my clients because they have to deal with the fallout of the disruption of benefits with what will probably be retroactive notice, because we will probably find out about the non-assignment of those contracts post-closing after the employees that go with the sale will now have to tell people the benefits did not go with them with the sale.
And so so what you really want is you want notice before it closes as to if there's going to be any change. Is that fair?
It's perfectly fair and very accurate, Your Honor.
Okay. And so if a notice is given to your client that the benefits programs are going to be assumed, you get your 3-day notice in paragraph 16. If there was a provision that says you will get the same 3-day notice if there is a change of heart prior to closing, have you then accomplished what you want to accomplish?
Yes, except that I think when trying to give reasonable notice to my clients, you can give reasonable notice to employees who call.
Right.
If it were key to closing, I would say I would look for a larger notice prior to closing. And just to be fair, Your Honor, if that is where Your Honor's leaning, the first notice really wouldn't be necessary. It would only be, if we could change the whole thing to say it'd be just prior to closing, 10 days prior to closing, something like that.
No, I haven't figured out a direction yet. I'm just trying to understand your issue. And so I think where I'm landing is what you're really trying to do is you're trying to avoid a practical problem of potentially giving misinformation to affected employees and being able to effectively write the script for folks who are answering the phones for your client. Is that fair?
It is exactly correct, Your Honor.
Okay, all right, then I think I got it. Mr. Wallen, do you now understand the issue better?
I do, Judge. At least I think I do.
Okay. It seems to me that especially, and we've only got one party that's complaining, and they're somewhat uniquely situated, and I would think that we would want to go sort of an extra step for the employees, because obviously if benefit programs aren't going to be continued or there's going to be a transition, a whole host of issues having to do with, especially with health insurance, that we need to be sensitive to. Sure. And it would seem to me that being able to, and I agree with what Mr. Whistler said, so long as he's got the ability to accurately answer the questions that are invariably going to come as to what's going to happen, and I'm not putting words in his mouth, but he doesn't genuinely care. He wants to be able to say, look, all of my people who are on the front line, who are answering the telephones, when you get this call, this is what I want you to say. And he wants to be able to have certainty that when that information goes up, because you know how this will go, if it changes, it'll be Cigna's fault. It won't be anybody else's fault. It'll be Cigna's fault. And to me, that's a rational request. And again, I would think something that we would want to be able to make sure that the employees have absolute certainty as to what's going to happen with a really important part of their lives.
Mhm.
So you want
So,
to,
Judge,
do you need to answer a text or an email, or you have thoughts about this?
I do, Judge. Since the primary concern is about open and transparent communication to the debtor's employees about what's going to happen with the debtor's policies, which do come from Life Insurance of North America as well as Cigna, it seems to me that the employees should be directed back to their internal human resources administrator, who the debtors can communicate with and provide a single source of information about the disposition of those policies. Would that be reasonable, Judge?
I would think, why don't you, as opposed to making people call, I mean, you got all your employees' email addresses, Twitter handles, text numbers. Why don't you send out when the decision gets made, why don't you send a notification out that will alleviate some of the pressure on Mr. Whistler's client, and also provide Mr. Whistler a copy of whatever it is that the company decides to send to its employees. To me, that seems like the right burden, but I'm happy to hear arguments to the contrary.
Judge, that's a much better idea. The debtors would be pleased to do that.
And Mr. Whistler, if that were the case, would that alleviate your concern?
If, Your Honor, that notice goes out a specific number of days prior to closing, and if we are included on that notice, then that will accomplish the two goals that I'm seeking. One is to give employees certainty, and some of that's still going to come through Cigna. As Your Honor said, it's going to be Cigna's fault. It's going to be Lion's fault. So if we get copied on that notice that the employees get, at least we'll be able to confirm that. The second is, just from any contract counterparty standpoint, Cigna and Lina want to know when the sale is closed what happened to our contract. So if that notice that's going to go out to employees and copy to Cigna is the definitive decision as to whether these contracts will or will not be part of the sale, then at least we'll know and we'll have final notice and we can take what action we need to take.
Sure. So I would think that with respect to, I mean, this is an important issue for a workforce. If a workforce is going to be transitioned, I would think this is actually going to be a topic of conversation probably early on. And just, I would envision the notice going to employees, Mr. Whistler, being something much more pragmatic as opposed to contract assumption and that sort of thing. It would be like, your health insurance will continue uninterrupted. I think it would be something less legal and more practical. If you want a communication from Mr. Wallen to you that confirms, under 11 U.S.C. Section 365, the following contracts are being assumed, I got it. But I was envisioning something much more pragmatic to the actual employees.
I appreciate the pragmatism, and I agree as to the employees that works. But like I said, we need the legal part so my clients know what is legally happening to their contracts.
I got it. No, and you're absolutely entitled to that. I wasn't suggesting otherwise. I just didn't want you to think that there was going to be a 365 notice sent to every employee. That wouldn't be worth the paper it's written on, in my view.
Understood, Your Honor. And just as an aside, I sincerely apologize for interrupting you. It was not my intent.
You were excited. It's okay. It happens every day. So, Mr. Wallen, let's do this. And I'm sorry, I didn't mean to ignore you. Yes, sir. You want to weigh in?
Yes, Your Honor. Just for the record, Shane Johnson from Porter Hedges on behalf of Inch House Interactive, the proposed stalking horse purchaser. I just really rose to say that I agree with Your Honor's proposal and to say that we're fine with that. To provide a little bit more color on the dispute, Inch House is a large publicly traded Canadian entity, and it is unlikely to assume these agreements because it has its own workforce, it has its own policies, but sure, just to, as a protective matter, wanted additional time to make the decision, and of course for other agreements needs additional time, especially because of there's a cure dispute and it goes against the way the debtors think it will go, needs to have some flexibility to reject contracts. But with respect to these contracts, is perfectly fine with what Your Honor has proposed.
Yeah, I look at these slightly different. I mean, if it were I'm making this up, if it were a supply contract, I got it. That, those folks care, number one, what the cure is, and making sure that there's an accounting done, and number two, that they have some confidence that they're going to get paid on a go-forward basis. I got all of that. What I would ask you to think about, I mean, I know that you're the stalking horse, and you may or may not be the ultimate purchaser. But if now that you've heard this, I would ask that you be sensitive to the issue, and if it turns out, and I'm just making up a set of facts, that it turns out that the Cigna programs, and I'm using that term generically, are not going to be assumed, that you think about early on providing a notice to all of the employees that says, you're going to be transitioned to, our Aetna plan, or I'm just making something up, so that there's that not knowing what your health insurance is going to be, especially if you have an issue, that can be really traumatic to people. And so I just ask that you think about that and be sensitive to it. Obviously, if you're not the purchaser, not your problem. But I would ask the same of any purchaser. Let me ask the parties this, and just contemplated realistic timelines. So, Mr. Johnson, sale hearing to closing in your view. And I'm not holding it to you. I'm just curious.
Yeah, Your Honor, what we've currently contemplated is having a sale hearing on July 7th. That works with Your Honor's schedule, and then closing before August 1st.
Okay. So a 10-day window doesn't get in the way of anything that you were contemplating.
No, that's fine.
Okay. So, Mr. Wallen, with respect to what I'm going to call the employee benefit programs, sounds like to me, just listening to Mr. Whistler, listening to Mr. Johnson, that a 10-day window on committing prior to closing should be just fine. And let me throw, because I've stood where you're standing. If something happens, then what I want you to do is I want you to file an emergency motion to come back and say, we had indicated we were going to assume the Cigna benefit plans, the world has burned down and now we're not going to be able to do that. And just file a motion on an emergency basis, give everybody notice, and that way there's then a subsequent court hearing that everyone will see and people can participate in if they'd like, and we can just go forward. And it seems to me at that point that's the right end. But otherwise, 10 days prior, decision gets made, whether it's Mr. Johnson's client or somebody else, and the debtor take on the burden of sending out, here's what we intend to do with your benefits.
Understood, Judge. So we would add potentially language here that says that we would give notice to Mr. Whistler's clients as well as our own employees about which, to use your term, employee benefit plans will ultimately be assumed. And of course, we'll make the employee notice, less legal jargon, more, go visit with, to use your example, Aetna about the transition, that sort of a thing. Just
right.
Straight to the facts.
And as opposed to just because you never know which is the right one of Mr. Whistler's clients to send it to, you just send it to Mr. Whistler. And why don't you send him why don't you send him a lawyer-to-lawyer communication as well as a copy of what you're going to send to employees so that he gets the benefit of both and he can talk to his folks, and to the extent that they need to come up with a plan, and they will, that you all are all on the same page as much as you can be. Does that make sense?
Understood, Judge. Yes.
And Mr. Whistler, are you okay with that?
I am, Your Honor. Thank you.
Okay. And Mr. Johnson, you're okay with that?
Yes, thank you.
All right, thank you. So, Mr. Wallen, that seems to me that those are really minor tweaks, and I know we have another objection to get to, but it just seems to me that that's a really minor tweak. Get that done, circulate it, and then let me know when that's been uploaded.
Yes, of course, Judge. Be happy to do that.
All right. So, U.S. trustee objection?
Yes, Judge, that is the remaining objection. As you know, the U.S. trustee objects to the inclusion of certain Chapter 5 causes of action within the sale process. The debtors view this as an objection to the sale rather than an objection to the relief we're seeking today, which is largely procedural. Of course, we are asking for substantive relief in the form of approving the bid protection to anointment of the stalking horse bidder, but we really see this as a sale objection that should be continued down the line. I don't know if Your Honor, if you'd like us to go ahead and argue the substance of it, but that's where we're at.
So let me tell you sort of my view of this, and again, you know, I do think that it is I do think that it's a sale objection. I do think that Ms. Thomas was smart to bring it up now, just so the issue's there. You know, my view is you can get an order that can sell avoidance actions, and then the purchaser then can't bring them. I mean, unless the estate maintains a significant interest in the outcome. That's just my memory of where the law comes out. I think if you sell 100%, you've effectively sold air. You know, if you sell a 50% interest in the recovery, you know, I think there are arguments against even that, but I think that you can do that. Mr. Johnson, you have thoughts about this?
Yes, Your Honor. Shane Johnson, again from Porter Hedges on behalf of the stalking horse purchaser, and agree that it's a sale issue, and you know we'll see where we're at the sale hearing if we're the successful bidder. But I'll just tell you, Your Honor, the purpose behind buying avoidance actions for my client is just to protect critical vendors going forward from being sued by somebody else. So
I got it. So if you buy them and then can't bring them, you're actually happy with that outcome.
Exactly.
I got it. Okay. But let's see how this all folds out. Ms. Thomas, one, do you think I'm just incorrect in my view of the law? And two, is this an issue that we can wait and see if it's actually a problem at the sale hearing?
Thank you, Your Honor. Audrey Thomas, attorney on behalf of the United States trustee. I agree with the parties that this really is essentially a sale objection. However, we thought it prudent to bring this objection at this time for three reasons. One, we think that notice should be accurate as to what people are actually bidding on. Two, at this point in time, we don't have any disclosure as to what these Chapter 5 claims are. They may be insignificant, they might be significant, but we've just appointed a UCC, and I think that there should be some investigation of those claims prior to them being included in a sale. And three, it impacts potentially the bargain that the parties are making in terms of the sale. So I appreciate why they want to include these claims in the sale process and why they might not want to pursue them. But I think case law indicates that they're really looking at for some benefit to the estate as part of these sales and for someone to have standing to bring these claims. And I'm looking at the recovery for unsecured creditors, and I think that's particularly important in this case because from the sale, it doesn't appear that there will be very much recovery for unsecured creditors, if any. And so just out of an abundance of caution, I wanted to raise the issue at this point in time because I think these Chapter 5 claims could be important for the unsecured creditors and their thoughts on the particular sales process.
So I got it. With respect to the subject matter itself, Mr. Wallen, perhaps maybe it is worthwhile in the proposed order just to drop a footnote that says that the effect of a transfer of avoidance actions from the estate remains an unsettled issue or something to that effect. And Ms. Thomas, would that satisfy you at least until the sale hearing that there may or may not be value attributable to that?
That would, Your Honor. Thank you. Yeah.
Okay. All right. It seems to me, Mr. Wallen, that's a fair request. And again, it may very well be, let me just pick on Mr. Johnson for a second. It may very well be that while doing the remainder of his due diligence, he may decide that what he's really concerned about are 15 different vendors, and they may just say this is just a whole lot easier if the company just grants a release of all avoidance actions to these 15 vendors, and we're gonna swap that out for a wholesale transfer. A lot can happen, but I think we all maintain a little bit of flexibility. This will all just not be an issue by the time we get there. Okay.
Understood, Judge. We will include that footnote in the minute proposed form of order we'll submit to you after the hearing.
All right. Thank you. And Ms. Thomas, do you have any notes or emails or anything regarding the meeting yesterday? Did they set a date to interview professionals? Do you know any of that? I was just trying to understand timing.
Thank you, Your Honor. And I wanted to apologize to Mr. Wallen. While he was making his proffer, I was messaging actually a member of the UCC, and I sent the message to everyone instead of just a member of the UCC. But they were concerned about the matters proceeding forward when they haven't had the opportunity to employ counsel yet. And I informed them shorthand that the BIP financing hearing had been continued out to that June 15th date. And so my understanding is that they are actively working to find professionals. They have spoken to, I think, a few before their appointment, and so it's just a matter of them setting official interviews with the committee and hiring professionals. They know that there are tight deadlines and that they need to move quickly in this case because there's a tight deadline to try to get the sale completed. So I think they're aware of the task and up to getting it done.
Terrific. Thank you. Anyone else wish to be heard? All right. Then with respect to the debtor's emergency motion to authorize bid procedures, I think the procedures have gotten better today. I think we've added some things that make the process more transparent, provides the right level of flexibility, and also addresses the needs of some constituents who are really important to the success of the reorganized debtor. So I appreciate everybody's involvement today. With respect to the procedures themselves, I find that the proposed procedures contained the required level of transparency that I always want. I think they're designed to achieve the highest and best value for the estate, for the assets involved. It'll never be enough, but we're all going to do our best to maximize what the ultimate number is. I'm comfortable with the notices. I'm comfortable just with the entire process. So I will grant the motion subject to the submission of an order that incorporates those things that we have talked about on the record today. Mr. Wallen, I'm going to want you obviously to circulate to Ms. Thomas so she can look at that footnote, to Mr. Whistler so we can see the changes, and quite frankly anyone else that is right. Interested in what changes were made to the order. Do we need to? Did you get dates from Mr. Alonso, or did you just put in dates that you wanted?
I actually reached out to Mr. Alonso yesterday, and the July 7th, 10 a.m. sale hearing date was reserved with his input.
Far be it from me ever to differ with Mr. Alonso. So then you've got the dates that you need. All right. With respect to the bid procedures motion, I know we've got another motion, but with respect to the bid procedures motion, anything else we need to talk about?
Not from the debtors, Judge.
All right. Thank you. Then with respect to cash management, and Ms. Mackle, I think that was yours, correct?
That is correct, Your Honor. Good afternoon, Shea Mackle of Pachulski, Stain, Deal, and Jones, proposed counsel to the debtors. The debtors seek approval of their cash management motion on a final basis. That motion was filed at docket number 8 and was supported by the first day declaration, which was filed at docket number 7. The court granted the motion on an interim basis at the first day hearing, and that interim order was entered at docket number 43. As I noted at the first day hearing, the motion reflects the standard request to allow the debtors to continue their existing cash management system as of the petition date. The Office of the United States Trustee had comments to both the interim order and the final order, and those were incorporated prior to filing the motion. Those comments included adding a requirement that the debtors contact their banking institutions to request that the bank accounts be reclassified as DIP accounts. And the interim order and proposed final order provided a deadline of June 16th for those accounts to be in compliance. And just by way of update, the debtors have reached out to all of their banks, and at this point, 17 of the 18 accounts now have the DIP designation. The company is working to ensure that the DIP designation is added to the single remaining account, and we do not anticipate a need to have that June 16th deadline for compliance needing to be extended. The debtors did not receive any objections to the motion, which is reflected in the certification of counsel entered at docket number 91. So unless the court has any questions for me, I would ask that the court grant the motion on a final basis, and the final order is at docket number 8-2, and alternatively at Exhibit A to docket number 91, the certification of counsel.
Right, thank you. And Ms. Thomas, could you just confirm that the final version of the order has your comments in it and the U.S. trustee has no objection?
Thank you, Your Honor. The U.S. trustee has no objection. I have not looked at the exhibit to their certification, but I trust the counsel. The prior version that they had provided to me included all of the U.S. trustee's comments, and thanks to debtors' counsel for ensuring that these bank accounts get reclassified as quickly as possible.
All right, thank you. Anyone else?
And I can represent that I...
Sorry, Ms. Mackel, go ahead.
Oh, sorry, Your Honor. I was just going to say I can represent that I did check the final order today that we proposed, that both docket number 8-2 and Exhibit A to 91, which includes the U.S. trustee's comment.
All right, thank you. Anyone else wish to be heard? All right, then with that, again, I think that we have found the right balance, just given the requirements of the code and also the practicalities of operating a business in today's commercial world. I don't have any concerns at all. I'll grant the motion using the final form of order that was submitted at 8-2. That has been signed, and it's off to docketing. What else do we need?
Your Honor.
What else do we need to talk about today? All right.
I believe that's all from our end.
Thank you. Mr. Wallen, just let Mr. Alonso know once you've uploaded the revised bid procedures order. And with that, everyone have a wonderful day. And the parties that are on for the 145, just give me one moment. We'll get started.